So the NCAA, the organization that controls college athletics and college athletes, and most particularly says that those college athletes can't be paid, just lost a 9-0 decision around college athlete compensation. But this is not at all the end of the story. Let's talk about what this decision actually says, what it doesn't say, and what's in the future for the NCAA. All right, I'm Nick Rekieta of Rekieta Law, a small law firm in central Minnesota. I'm a lawyer. I'm also a legal and political commentator on YouTube and on Odyssey. Wherever you're watching, go ahead, hit like, hit subscribe, turn on your notifications. Make sure you don't miss any videos. All right. So the NCAA is the organization that controls college sports at the relevant levels. I mean, there are like intramural activities and stuff like that. We're talking about college sports, the stuff you see on TV, football, baseball, basketball, those sort of things at the highest levels of competitive play before they go pro. The NCAA has long held that students are not to be paid for their efforts because it maintains a level of purity for the play. It fosters a love of the game and a focus on academics rather than money. Of course, while saying this, while espousing these beliefs, college sports in general has generated billions and billions of dollars in revenue that goes to colleges, that goes to college administrators, that goes to coaches, that goes to the NCAA itself, but it doesn't really go at all ever to the athletes. The only compensation athletes are really allowed to have is a scholarship. That scholarship can include some level of housing, but that's about it. Everything outside of that scholarship, they cannot do anything with, including monetizing their own names, images, and performances. College athletes cannot, for example, accept brand endorsements. A real question I would have right now is, can a college athlete sell an NFT, right? A non-fungible token, these new digital assets of themselves related to their playing of sports? I don't think they can right now, and that is pretty insane to think about. They cannot compensate themselves based on their own activity. They can't accept endorsement deals, all of that stuff. The only benefits that they can get are a scholarship. Now, a scholarship can be worth quite a bit of money depending on where you're going to school, but a lot of people would suggest that the amount of money that top-level college athletes generate for a program outweighs the amount that they're being paid on their scholarships. So that is sort of the question that was presented to the Supreme Court. Well, it was actually, let me scale back a little bit. It was presented to a district court, and the district court was given a broad swath of pay exemptions that the NCAA has put in front of it. Now, the district court actually cut that both ways. They did not prevent most of the pay restrictions on college athletes. They allowed them to stay. What they said, however, though, were certain education-related benefits for college athletes were too strict, and they allowed those education-related benefits to go forward and to be removed from the NCAA, and to allow schools to do things like provide, for example, a scholarship for graduate school after their eligibility requirement ends. So you're only eligible to play college sports for so many years because they don't want college teams having someone effectively be a pro player for 9 years in college and just never graduating and keep playing. So they have eligibility requirements that limit the amount of years that they can actually play in sports. And those eligibility requirements impact if they move colleges. Like if you're playing at one school and you say, hey, I want to move to a different state, you move to a different state, you may lose a year of your eligibility, which can put a big damper on things. And it's intended to limit trading students between different schools to create a better sports ball team, right? So that's why those limits are in place. But they also had limits on how much could be offered, for post eligibility. So let's say a student graduates but they want to go to grad school and finish out like a physics major or a business major or something like that, they were not allowed to offer scholarships to those players after they graduated. So this kind of impaired the ability for college athletes to go on to do graduate school, because they would then have to fund it themselves rather than having some sort of scholarship opportunities available for them. The court said that those restrictions went too far and needed to end, but many of the other restrictions stayed in place. So now college athletes, many of whom do not go into pro sports, right? There's a bunch of college athletes and a lot less professional athletes. And so the amount of college athletes that actually go from playing sports into professional sports is a pretty small number. That's why some of these postgraduate education benefits could be really useful to some of these guys who are not, and ladies, who are not going to go into professional sports after this, but they want to complete a higher education degree. And, some of the billions of dollars that the college received, on the labor of these people can be maybe rolled into some postgraduate opportunities. So that happened at the district court. And then that went up to the appeals court, which said, nope, this is a good balance. We're going to keep it. And then that went to the Supreme Court. Now, the Supreme Court was limited because only the NCAA appealed this decision. The players themselves who brought the suit in the first place, they did not appeal to try and expand the rules to every other piece of compensation. And right now, I assume those players are kicking themselves because they won 9-0. And while they won, there's a really important piece from a concurring opinion that we're going to read in just a second that indicates that this fight is far from over for the NCAA, but it probably could have been put to task at the Supreme Court level in this particular case. But since they didn't bring it, the Supreme Court was limited in scope to what they could actually do for college athletes, and that is to uphold the injunction set by the district court that prevents the NCAA from restricting these education-based compensation. All right? So, with that said, we're going to read from Justice Kavanaugh's concurring opinion. Remember, this is 9-0. And the opinion was written by Gorsuch. It's a very, very thorough and complicated opinion, and it requires a lot of knowledge of the Sherman Antitrust Act. That was the grounds used to attack the NCAA here. They said this is a trust, this is a monopoly, and with monopoly control, they're suppressing wages, which is true. That was absolutely correct, and that's the approach that they took. So Gorsuch wrote the opinion. Kavanaugh added about a 5-page opinion. And this 5-page opinion drops some blistering warnings for the NCAA and their future restriction of compensation for players. That's what we're going to take a look at real quick to close this out, because I think Kavanaugh is on the right track here. I think he agrees with the same sentiments that I feel about the NCAA. I was never a college athlete or anything like that. I mean, look at me. That doesn't matter. I have long held that these students should be allowed to receive compensation for what they do because they bring colleges tons and tons of money. If nothing else, they should be able to monetize their own name and image in some sort of way. Now, some people are going to disagree with that. Some people are going to agree with that. That's fine. That's just been my opinion for a long time, is like these guys are bringing in tons of money. And if you go to even small schools, their sports programs bring in a lot of cash, and they are kind of the hallmark of the school in some way. And so I think these guys should be able to get a little piece of the very big pie that their school is gorging themselves on because their labor is contributing to it. But let's take a look at what Kavanaugh says here. I'm going to just read a couple of these paragraphs because they're great. The NCAA acknowledges that it controls the market for college athletes. The NCAA concedes that its compensation rules set the price of student-athlete labor at a below-market rate. And the NCAA recognizes that student-athletes currently have no meaningful ability to negotiate with the NCAA over compensation rules. So he's setting the groundwork, and right now the NCAA should be like, oh, this doesn't sound good for me. The NCAA nonetheless asserts that its compensation rules are pro-competitive because those rules help define the product of college sports. Specifically, the NCAA says that colleges may decline to pay student athletes because the defining feature of college sports, according to the NCAA, is that the student athletes are not paid. Notice what's happening. He's talking about only the NCAA because they're a monopoly with something called monopsony power. That means they're the only buyer in the market. There's no one else. And the NCAA kind of tries to defend itself and says, no, we're not a monopoly. Look at all of these, we're a joint venture with all of these other organizations that come together to agree. That's still a monopoly, bro. You still have the only buying power in the market, and that is the problem here. And that's why Kavanaugh is using NCAA as many times as possible. In my view, that argument is circular and unpersuasive, he says. The NCAA couches its arguments for not paying student athletes in innocuous labels, but the labels cannot disguise the reality. The NCAA's business model would be flatly illegal in almost any other industry in America. All of the restaurants in a region cannot come together to cut cooks' wages on the theory that customers prefer to eat food from low-paid cooks. Law firms cannot conspire to cabin lawyers' salary in the name of providing legal services out of a love of the law. Hospitals cannot agree to cap nurses' income in order to create a purer form of helping the sick. News organizations cannot join forces to curtail pay to reporters to preserve a tradition of public-minded journalism. Movie studios cannot collude to cut slash benefits to camera crews to kindle the spirits of amateurism in Hollywood. Price-fixing labor is price-fixing labor, and price-fixing labor is ordinarily a textbook antitrust problem because it extinguishes the free market in which individuals can otherwise obtain fair compensation for their work. Businesses like the NCAA cannot avoid the consequences of price-fixing labor by incorporating price-fixed labor into the definition of the product. Or to put it in more doctrinal terms, a monopsony cannot launder its price-fixing of labor by calling it product definition. The bottom line is that the NCAA and its member colleges are suppressing the pay of student athletes who collectively generate billions of dollars in revenues for colleges every year. Those enormous sums of money flow to seemingly everyone except the student athletes. College presidents, athletic directors, coaches, conference commissioners, and NCAA executives take in 6- and 7-figure salaries. Colleges build lavish new facilities, but the student athletes who generate the revenues, many of whom are African American and from lower income backgrounds, end up with little or nothing. And that is the key. His final line really sells it, though. Here we go. The NCAA is not above the law. And that is really the gavel drop on this one. Kavanaugh nails it. And he's 100% right in all of this stuff. Now, he does go on in the next couple paragraphs before someone comes shrieking at me in the comments talking about, yeah, it's going to be tough to figure out what college compensation would look like under this and how schools are going to pay. And there's a whole lot of athletes and it's not really clear how much they're going to get paid. But at the end of the day, he says, but the law is the law. And you can't just decide to not pay anybody because you don't want to pay people. Like, you've got them working, you've got them doing labor and generating a large amount of money. That needs to be compensated. Now, again, it's important to remember that this decision does not do that. Kavanaugh was laying out a structure of sort of policy argument about what case is to come. So one of the really important things that happened in this decision is that they established that these rules are subject to Sherman antitrust legislation, that the current Antitrust Act governs certainly the rules that were prevented, right? Like, those are clearly under the act and they violated the act, so they're no longer allowed. However, just because the ruling today is only limited to the factors that were before the court does not mean that other factors cannot come before the court under the same analysis. So we're going to probably see some players get together and sue the NCAA under this act with the recognition that the act applies to this other compensation. The court didn't find that those rules are okay those rules were not before the Supreme Court. And that's a very, very important distinction. They couldn't mess with them because it wasn't in the purview of the case. So they're limited. But those rules are not similarly limited just because they weren't in the purview of this case. They just need a new case to be brought against the NCAA to round out where those rules should stand under the proper analysis. And we may see that happen in this case if it gets, if there's any sort of revisiting of the issues from the same group. We'll see. Otherwise, a new group, it's on the horizon. The NCAA, I think their time is very, very limited in not paying these student athletes. And when you think about it, try and find other industries that generate this much money, that are this publicly popular and well-known and engaged in, and do not pay their workers anything even close to what would be considered a market wage. But that's my thoughts on it. Why don't you tell me what you think down in the description below? And until then, I'll see you next time. Peace. Peace.